The Office of Victim Advocate is the state agency with the duty and authority to advocate for the rights of crime survivors. Pennsylvania state law recognizes that victims of crime have rights. You have the right to be told about basic services available to you in your county, court events including information on bail, escape or release of offender, preliminary hearings, trials, guilty pleas, sentencing, and the details of the final disposition of a case. You have the right to receive notice of the arrest of the offender, information about restitution and assistance with compensation, accompaniment to all criminal proceedings by a family member, a victim advocate, or a support person. You have the right to offer comment before the sentencing decision and to receive help in preparing a verbal or written victim impact statement, and also before post-sentencing decisions, including parole consideration, pardons and clemency, medical or compassionate release. At the Office of Victim Advocate, we work with crime victims to make sure their rights are upheld as they navigate their way through the complex legal system in a manner that recognizes trauma and how it impacts our lives. We encourage crime survivors to register for services with the Office of Victim Advocate. Benefits of registration include awareness. The Office of Victim Advocate will help keep you informed of an individual's movements throughout the state correctional system. Assistance. The Office of Victim Advocate will assist you in preparing statements and comments before the PA Parole Board and the PA Board of Pardons. Advocacy. The Office of Victim Advocate operates a call center to answer your questions and advocate on your behalf. Access. The Office of Victim Advocate offers several special projects to build resiliency and support the healing process like Resilient Voices, support groups, victim offender dialogue, inmate apology bank, impact of crime courses and trauma trainings, as well as numerous efforts to support crime prevention and restorative justice as we work collaboratively with local county service providers to build safer, caring communities where justice thrives.
Welcome to Monday Night Meetup. I'm your host, Commonwealth Victim Advocate, Suzanne Estrella. You have entered a safe space for thoughtful reflection and honest conversation. There is no expectation of privacy. We are recording this session for our YouTube channel and we're streaming live on Facebook. Well, it's February, so I want to start by giving a shout out to Black History Month. I'm compelled to acknowledge all the fierce Black advocates that have come before me. It's through the lessons I've learned from so many others that I'm able to occupy this space today. Learning how others use their voices when facing injustice has empowered me to strive to do the same. I'm grateful to be a part of such a rich history, and I'm hopeful that during February that all people will take the opportunity to be intentional about reflecting on Black American history and perhaps learning something new. Tonight, we're going to be talking about crime victims' rights. I'm joined by two guests, Kathy Buckley, who is the director of the Office of Victim Services with the Pennsylvania Commission on Crime and Delinquency, and Andrea Levy is the legal director of the Pennsylvania Coalition Against Rape, where she manages the Sexual Violence Legal Assistance Project. As we get started, I just want to lay a foundation for our discussion. Like we said, we're talking about crime victims' rights, and hopefully you've had a chance to see the video we just showed. But just in case, I'm kind of going to go through some of those rights as they appear in the statute so everybody's clear on what we're talking about. And the reason why this is, they're not new rights. I want to point that out. These rights have always have been in the statute for some time, but most recently the statute has been amended to allow what is called standing. And we're going to talk a little bit about what that means. But now the rights are there and survivors have standing to try and enforce those rights. So first, let's start off with just going through like a brief summary of what the crime victims' rights are. So you have the right to receive basic information concerning services available to crime victims. You have the right to be notified of certain significant actions and proceedings. You have the right to receive information regarding whether a juvenile offender was detained or released following arrest and whether a petition alleging delinquency has been filed. Significant criminal and juvenile proceedings by a family member, a victim advocate, or other person providing assistance or support. In cases involving personal injury, burglary, or DUI involving an injury, you have the right to submit prior comment to the prosecutor's office or juvenile probation officer on the potential reduction or dropping of any charge or changing of a plea in a criminal or delinquency proceeding. You have the right to have an opportunity to provide comment on the sentencing of a defendant or the disposition of a delinquent child, to include submission of written or verbal comments or a verbal impact statement. You have the right to be restored to the extent possible to pre-crime economic status through the provision of restitution, compensation, and the right to the expeditious return of property seized as evidence. In personal injury crimes, when the offender is sentenced to a state prison, you have the right to provide prior comment on and receive notice of release decisions and to be immediately notified of any escapes. You also have the right to receive notice when an offender is committed to a mental health facility from a state prison and of the discharge, transfer, escape, or recapture of the offender from the facility. And you have the right to have assistance in preparing, submitting, and receiving information regarding claims for victims' compensation. That's a lot, right? Let me sum it up. Basically, what that says in a nutshell, you have the right to know, you have the right to say, and you have the right to compensation. And that's just making it really, really simple. But these rights are in the Pennsylvania statute. And now survivors have an opportunity to address those rights if there is a rights violation in a different way than what you had before. So let's get started with talking to some of our guests and just I'll let you introduce yourself a little more if you'd like, and just tell us, we'll start with Kathy from PCCD. Tell us what you are hoping Act 77 will achieve for crime survivors. And Act 77 is the name of that amendment that is providing this standing. Like I said, they're not new rights. The rights have been there, but now with this amendment to the law through Act 77, crime survivors now have standing to try and enforce these rights. So Kathy, tell us what you think that's going to mean and what you're hoping will happen as a result of this.
Well, thanks for having me. I'm grateful and really appreciative to be a part of the discussion here this evening. So I've been in victim services for about 3 decades now. And so I've been very aware of victims' rights whenever they first came into being a number of years ago. I think it was 1984. And we've added a number of rights since then, right? But even hearing you talk, Suzanne, you think about, what does disposition mean? Right? What does an arraignment mean? What does a preliminary hearing mean? And why does the hearing keep getting continued, every month? So having victims' rights and having to be involved in, forced into a system that you didn't choose to be involved in, then it's like, how do I learn about this? That's the first challenge. How are victims being made aware of their rights and services? And then once you understand what those rights are, how do you know if I've been given those, right? So it's working with victim services and victim advocates is really paramount to walk people through so they can help with that understanding. But what I guess I hope it will achieve in Act 77, I have a couple hopes. One is that I hope that victims and survivors will feel more validated, right? Because they've always had these rights. But I think Act 77 will hopefully open up a lot more avenues in that regard, that they're going to feel like they're not looking from the outside in, but they're already in, right? I feel like we have a long way to go, but Act 77 just takes Pennsylvania to the next level. We've always had rights, just like every other state, but now legal standing, which is another thing. What does that mean? It's a foreign concept. What does that mean for victims? And so I feel like that, I hope that it's going to start providing victims a sense of justice, because they've always had these rights. Now they get to seek enforcement of those rights. And I know that Andrea will talk a little bit more about that, but now they have an avenue where it's like, hey, wait a minute, my rights just as important as the offenders. So I want my rights to be enforced to make sure I get that too. So my hope is that it's going to achieve more of a sense of inclusion and a sense of equitable and parity within the system, just like everybody else. And a quote that I always think about is, true freedom requires the rule of law and justice, and a judicial system in which the rights of some are not secured by the denial of rights to others. So I think that just speaks to that equitable parity when it comes to rights that I hope Act 77 provides.
Awesome. Also, I do want to say too, if you're listening and you have a question that pops up, please type that in the chat and we will address any questions that we receive on crime victims' rights, and we'll try to get those answered for you. I do have some questions that survivors previously provided, and we're going to go through those as well. But if you have a question while we're talking, please feel free to type that into the chat. Okay, Andrea. Now, moving over to you for an even tougher question, I'd say. What does it mean for a survivor to have standing?
I just first want to say thanks for having Kathy and I to your show this evening. It's a privilege for me to appear here with the two of you. And to answer the question, when we talk about standing, it's a legal term. That means an individual is permitted to go before a court and ask for relief. So generally, in any area of the law, a person must have legal standing to go before a court and seek a remedy. So in the context of a crime victim, prior to Act 77, which is the amendment you were speaking of at the beginning of the hour, Suzanne, there were really only two parties when there were criminal charges in court. One was the defendant, or the person who was accused of the crime and facing the criminal charges, and their attorney, which would be a criminal defense attorney. And the other party was the district attorney or the prosecutor for the Commonwealth of Pennsylvania or for the county. And the prosecutor would go before the judge and the jury and try to prove the case and obtain a criminal conviction. So what was missing from the process in the past was a platform for a crime victim and their own attorney to intervene to protect their rights in the event that those rights were infringed upon. So with the passage of Act 77 last year, crime victims and their own personal attorney now have legal standing to go before the judge in this criminal justice process that I just described a little bit and have their rights enforced. So having this legal standing is a tremendous step forward for crime victims in Pennsylvania, because it means that they now can get before the judge in a criminal case and have the rights that you listed also in the beginning actually asserted and or enforced. But it's also important to note that once a crime victim is in front of a judge, they cannot just ask for anything that they want to have happen or anything they want to see happen in the criminal justice process. The victim is going to be limited to asking for the rights that are afforded to them under Pennsylvania law. And those are the rights that you listed. And if you don't mind, I'd like to repeat some of them
Sure.
for whoever's listening. And when I go through them, it's not going to be the exhaustive list that Suzanne went through at the beginning, but it's just generally what some of these are. And keep in mind, it's once there are criminal charges filed by a prosecutor is when a lot of these rights kick in. And one is, in general, the right to information about the proceedings, right to notice of and presence at the proceedings, the right to restitution, which we talked about, the right to have personal property returned to you if it is no longer needed as evidence in the case, the right to be advised, and this was the notice Suzanne was talking about, on plea deals, on sentencing, on release from prison, on bail conditions, the right to be accompanied to court proceedings by a support person of your choice. And if you don't mind, I would like to talk about some other rights that would specifically impact victims of sexual violence, because that is the work that I do at the Pennsylvania Coalition Against Rape, the legal work that I do. So there would be certain rights of privacy. For instance, conversations between a sexual assault counselor and a victim are privileged, which means they're confidential, and a defendant or a criminal defense attorney would not be able to discover the content of those conversations. Child victims have a right of certain accommodations and privacy when they are forced to testify in court. Rape victims have the right to free medical forensic examinations, and they have the right for the evidence collected during a forensic exam to be preserved, which that hasn't always been the case. Sexual assault survivors have the right to disclosure of information about evidence collected from forensic testing, and the right to notification of a match that might be found to another DNA profile. And just for a few more minutes, those are the rights that, just a small list, it wasn't the exhaustive list, of the rights that a victim can now have standing in court to assert or seek enforcement of. And the rights can be raised by the victim on their own, by the victim's attorney, their personal attorney, should they have one. But the rights could also be raised by the prosecutor on behalf of the victim. And, we should probably note that there can be other issues that arise in the criminal justice process wherein the crime victim is not going to have the right to seek a remedy. And I'll just list a few of those. So we can think of these as limitations, potentially, to what a crime victim could ask for when they go before the judge. One would be, a victim generally does not have the right to sue the state, the prosecutor, or the court for a monetary damage award, even if one of these rights is violated during the criminal justice process. So the remedy there would be to have the right enforced, to have the application of the right, as opposed to some sort of monetary award as compensation for the right being violated. Victims do not have the right to force a prosecutor to drop a case. Victims generally do not have a right to force law enforcement to investigate a reported crime, or to force a prosecutor to bring specific criminal charges, or really any charges at all, against an accused person. That falls under what is called prosecutorial discretion. Crime victims do not have the right to veto or overrule completely a plea deal offer to a criminal defendant. And typically, victims are not going to have the right to dictate what the sentence for a convicted person should be. So a victim may give input about the sentencing or the plea deal, but cannot overrule a prosecutor's decision on a plea offer or a court's decision on sentencing.
Right, those are all super important. And I think it kind of it ties back nicely into something that Kathy said in the beginning. And I'm gonna pull from your experience a little bit, Kathy, since you mentioned that you've been doing this for 30 years. That's phenomenal. Thank you for the work that you do. But over that time period, I'm thinking that one of the things that is so important and significant to this is communication. And like that first, the right to basic information. What are some of the ways that crime survivors currently get that basic information? What would you say somebody, we have someone who was posted on the chat, and they're saying that their granddaughter was killed in December. What are some of the rights that that family has? How will they access that information?
So one, my condolences to the person on the death of her granddaughter. But you're right, communication is so key. And I want to reinforce something Andrea just said too, is that we want to be upfront, right? We don't want to give victims information that we know may not be accurate. So to me, the more accurate the information, the better service that we do for victims. And so basically saying you can't sue somebody, or you can have input into pleas and into victim impact statements and so forth. But when it comes to the decision, we always couch that as you have a right to input, but it's not a veto, right? So it's understanding what that role is and how those rights tie in. How victims can access the information, we've been trying to do this in a variety of different ways. First, and just so people have the context, I worked in a victim service agency, but now I provide funding to the victim service agencies that carry out all these services that Suzanne's office does and Andrea's organization does. And so first and foremost, law enforcement is required whenever they respond to provide victim information, rights, and services. And they're supposed to do that right at the first contact or as soon thereafter. So the goal is, and that's part of the Crime Victims Act, to make sure that victims get that information up front so you'll know who to call. You can call that victim advocate. You can see what the information is about your rights. We're providing everything through the electronic link to. There's a website that is actually been created by crime victims for crime victims. And I can put that information in the chat as well. But all you have to do is type in your internet browser, Pennsylvania Crime Victims, and that'll be one of the websites that come up. In there is also delineates all those different rights and information and services that you can access that way. And we also, and I know all of us, OVA, PCAR, our sister coalition to the Coalition Against Domestic Violence, and us, we all have on our website information as far as who your local programs are, your local victim service programs. And they are the lifeline. They're the ones that will work with you, hold your hand, help navigate the system and understand what your rights are. And so that's, to me, going to be where you're first and foremost that you go, where you go for this type of information. And then you have those that work in the prosecutor offices. If the case is in the criminal justice system, somebody's been arrested, you're going to be contacted by a victim witness coordinator that's also going to be providing you with the same type of information. Because what we know is more often you get the information, the more it's going to sink in and resonate. We know how trauma can impact the memory and being able to process the information.
Right, that's great. So yeah, and also we just want to offer at any time, if you're having trouble finding that connection in your local county, please feel free to reach out to OVA and we can make sure that we get you contacted with the victim service advocate who's closest to you, can help walk you through that process. So I hope that kind of makes it a little bit clearer for the person asking about the rights of the family. If this is a case where someone's already been arrested, someone should have already reached out to you. If not, at any time, if you want to call us or contact us, we can see where you are in the process, and maybe if we can provide some more detailed information that directly relates to where you might be in that process, and making sure that you are understanding the information that's available to you and what your rights are. We do want to make sure that we can provide as many services, as much help as we possibly can. All right.
Suzanne, I'm sorry. Do you want me to kind of go through what a few of those rights are that her family should expect?
Oh, sure. That'd be good.
I feel like because she's asked, let's talk about a few of those. And one of them is that you have the right to be notified of significant actions of your case going through the system. Both Suzanne and Andrea talked about that. So you'll get information about a hearing has been scheduled, a preliminary hearing, if you will, and then some other types of things like trial or other terminology called trial, called the list and so forth. So that's the foreign pieces of information. but that's what that victim advocate's going to help you with. Then whenever charges are filed and there's a potential discussion of reduction of charges, you have the right to provide input into that, which we had spoke about earlier. And then also the victim impact statement. You also have the right to be accompanied by a family support person or a victim advocate to the proceedings. You have the right to request restitution. You have the right to victims' compensation, which I know I'll be getting into a little bit later here. But in layman's terms, there's a whole host, as Suzanne and Andrea have spoken about, but some of the key ones to keep in mind are those.
Mhm. And this is a good time to go ahead and talk about victims' compensation, because even if you're not at the trial stage, it may be the time where you want to fill out a form for victims' compensation. So Kathy, talk a little bit about victims' compensation and what is available. And we'll go ahead and type that form in the chat too, so people can see how to access that.
So you're absolutely right, Suzanne. You don't want to wait till the trial to apply for victims' compensation. You actually want to do that as soon as you can. So victims' compensation is a program that every state has, and it's a reimbursement program. So it reimburses financial expenses that crime victims experience as a result of the victimization. So it reimburses uninsured and unreimbursed expenses like funeral costs, medical expenses, counseling and therapy, loss of earnings, loss of support in cases of homicide, relocation expenses, crime scene cleanup. But when I say all that, the most that we can reimburse for is a maximum of $35,000. Now, some of those expenses that I just spoke about do have what you call caps, meaning that we can only pay so much on certain expenses. For example, funeral expenses, we can only pay up to $6,500. For counseling, we can only pay up to $10,000 in expenses for children and $5,000 for adults. And to be eligible to apply for victims' compensation, there are a few criteria. One, that the crime occurred in Pennsylvania. Now, if the crime happened in another state, then you would apply to that state's compensation program. You also have to file the claim within 5 years of the crime happening. You must report to the proper authorities or have a protection from abuse order, sexual violence protection order, or protection from intimidation. And you must cooperate with the police or law enforcement and the compensation program. We also have another type of claim called sexual assault counseling claims. And so this is a recent piece of legislation that passed in 2019. And those requirements that I spoke about, that you must report to the police and file within 5 years, do not apply in these types of claims. Basically, this is saying is that if you were sexually assaulted in Pennsylvania, that you can apply for a reimbursement of counseling expenses that occurred on or after November 26, 2019, when the law went into effect. The only thing to keep in mind is that we can only reimburse the provider. So we would not be able to reimburse you as the survivor seeking the services. The law is written that only allows us to reimburse the provider, which we do quite often anyway. So, and just to give you an idea about how often we reimburse, we paid out over $14 million in victimization expenses in 2022, and we expect that to continue to go up.
Wow, that's a tremendous resource. Someone's asking about they ask, can OVA help a family relocate? That is not something that our office does, but as Kathy just mentioned, if you meet those qualifications as a crime survivor, you could fill out an application and perhaps get some relocation assistance through their office. So I hope that answers that question. And let's make sure we get the links for how to do that into the chat box for them. All righty, Andrea, we're gonna switch back to you. And we talked a little bit about standing, but now I'm going to ask if you can kind of help us to really paint a picture of what that might look like. So let's say it was a sexual assault survivor and the DA enters a plea with an offender without the survivor being informed. What are some examples of what standing might look like in this case, or what you would do for that survivor to try to rectify that?
Well, the survivor would probably come to us and explain what you just did. You know, hey, a plea was entered in the case against my offender and no one ever told me, and I didn't get a chance to provide any input. So what would I do? I would think of filing a motion. It might look like a motion for reconsideration on behalf of the victim to the court. So I'd be asking the court to reconsider the plea deal that was accepted and potentially redo the entire scenario. So the victim could be advised of what, have notice of what was happening, be able to be present, and also to provide input on, their thoughts, whether they agreed with the plea deal or they were unhappy with it. To be a little more technical, it could be maybe a motion seeking enforcement of victims' rights to notice. It could look like that, or a motion for reconsideration. And assuming that the judge granted the motion, and that we are going to then, have the process redone, I would talk to my client and ask them, what are your thoughts on this potential plea deal that the prosecutor's office is wanting to offer the defendant? And I would listen to, what their thoughts are and what their wishes are. And I would advocate then on behalf of my client with the district attorney's office based on what it is they want. For instance, maybe the client feels like I want this case to go to trial. I want to have my say. I want to be able to testify. Other clients may feel like they would like some sort of plea deal in place, but maybe they don't agree with the exact terms that are being offered or put forth by the district attorney's office in that case. So in any event, I would advocate for something that made my client, the crime victim or the survivor of sexual violence, as the case may be for the work I do, that would further their goals for how they would want to see the case resolved. That being said, once the motion is granted by the judge and we're redoing the process, my role in advocating as the lawyer for the victim is sort of limited, because as we pointed out, a plea deal, a victim doesn't have ultimate veto power over it. But I could advocate and argue and try to persuade the prosecutor to sort of adopt what the client's wishes would be.
Right. And I think that's important. And the reason why we're stressing it, I imagine it may sound like, well, what's the point? But you do have the right to be heard. But it doesn't mean that once you're heard, that the prosecutor or the judge is going to agree with what you've said. But they still you have the right to be heard. So they have to listen to you first. And that kind of brings up what our office does. And that's, we actually already have a complaint process in place. So if you feel like your right as a victim has been violated, you can file a complaint through the Office of the Victim Advocate, and then we will advocate on your behalf, trying to get that resolved. And that is kind of like a little step in between someone going to the court and filing a motion to try to enforce that right. So we're kind of come in, because we've been doing it before the standing came into place. So it's a little bit just before you go to court to officially file a motion saying, hey, you violated my right. Some of the things that we've done is just kind of calling to judges' chambers and saying, hey, did you realize that this victim right per the statute was not upheld, and asking them what can they do or what are they willing to do to rectify that. And we have seen some success where, and I know one situation, it was kind of, sometimes it's like after the fact though, that it's something, it's not really something that can be fixed because the proceeding has already gone so far. One was in a case involving juveniles where the judge did not allow the family to bring the advocate of their choice with them. He had another advocate that was already working in the courtroom and said, we're just going to use this advocate. And once we explained that that was a violation of the statute, that they were supposed to have the choice, the judge did apologize, explained that he thought he was trying to keep the procedure more confidential, and was why he was only trying to use this one advocate, but did agree that he would not do that in the future. But it wasn't something that we could kind of like go back because the child had already been subjected to a different advocate and not the advocate of their choice. But the hope is that, you know, for future victims, they will not receive that same violation, that process will now be more victim-centered and trauma-informed. So at any time, if you feel like your right has been violated and you're not sure what to do, you can fill out the OVA complaint form. We will contact you to make sure we have all the details. We will ask you for permission to advocate on your behalf. And once you give us that permission, then we will move forward and contact the offending parties and see what can be done to try and seek a resolution. And then if necessary, we would refer you and see if maybe we can assist you in helping you finding an attorney if that's the right that you decide to go and file a motion to assert your standing of the right if that seems to be what needs to happen. So I want to make sure that the OVA complaint form is also dropped into the chat. So if anyone needs that, you would have that.
I'd just like to add, Suzanne, you know, a motion can be filed in the example that we gave about a plea deal. And so the plea deal gets to be redone, and then the lawyer for the victim, should they have one, and say that's me, is advocating for the person. And I've had cases like that where the prosecutor's office was very much wanting to hear from the victim who potentially didn't agree with a potential plea deal that was being discussed. And it was effective to advocate, and it influenced what the district attorney was going to offer. So there are cases where that type of legal advocacy is effective in moving the needle.
Yeah.
Within a prosecutor's office. Now, it's not all the time, and it's not for every request, but there is a role for that, and there is success that can be found.
Yeah, that's true. Another thing I think is worth mentioning, because I know when you're involved in trauma, there's like so many things to think of and so many things that are happening. But often we see something that comes in as a potential violation where it ends up being that the survivors have actually like changed phone numbers so that people were trying to make contact but could not make contact because phone numbers were changed, and then the new information was not provided to the district attorney's office. Something so simple, but when you're in the midst of so much, it's hard to remember, like, oh, I've got to let them know that my phone number changed. So just something else to throw out there that we want to be mindful of, that we have to keep that constant. If you're working with an advocate, the advocate can kind of help with that to make sure that your contact information is always updated. Let's see, it looks like we've got another question in the chat. Someone was re-victimized by media. What are my rights? I'm not exactly sure what the person means by that question, but I don't know that that's really one of the rights that we're talking about that's enumerated in the crime victims' rights. Does not address contact with the media or media office. So I'm not sure. You can call us. So for if you want to give us a little bit more details, and maybe we can offline provide you some answers or assistance with that question. Let's go into a few other questions that we kind of got in advance from some survivors. And either one or both of you can answer and we'll see how it goes, okay? In regards to accompaniment to all criminal proceedings by a family member, a victim advocate, or a support person, does this include police interviews of a victim?
I'll give the answer, the lawyerly answer. It depends. It's going to depend. I mean, it's just going to depend on exactly what the situation is, and what stage of the investigation is it? Is it just taking preliminary information, or is it very fact specific into the actual crime that occurred? In many cases, when it comes to sexual violence, a sexual assault counselor will be present for legal accompaniment, even with law enforcement present, because there is a privilege there, which means that the information will be held completely confidential. So there's a confidential concern, a confidentiality concern, I think, with some of those interviews that may arise.
Yeah, some of them, let's say like non-sexual assault, the answer could be no, because it could be that that's not a criminal proceeding. I think that's, and then the other thing, it's gonna probably differ county to county on how they're working with crime survivors, but it is possible that if they're just talking about an interview, that is technically not a criminal proceeding, and an advocate or family member might not have the right to be there. So, but like I said, in some places you will find that the interviewers are going to want to do what makes the person feel most comfortable, but that is not always the case. And it could very well be that the right has not yet initiated, because it's technically what they're doing is not a criminal proceeding. So that's a tough one. Did anybody want to add anything else to that one?
That's what I was going to say, is that it depends how they define justice proceedings. And so to me, that's, as Andrea said, is a lawyer question, but I agree with you that it might not qualify as a justice proceeding, a police interview, but
Yeah.
Until somebody brings a case forward,
Yeah.
it could change.
Yeah. You can always ask.
Yep.
So, yeah. All right, here's another one. What can I do if the offender doesn't pay court-ordered restitution?
I would first probably contact the probation officer, the parole officer who is supervising the individual, because that's one of the things that they do as part of their caseload and supervising the offenders is what is their payment plan and process, and probably also go to the courts, the clerk of courts, or someplace that actually does receive the collection. I would start there first.
Yeah, and I would advise to start sooner rather than later, because if the person finishes their sentence, their parole period, or whatever, then you're kind of out of gas, unless you can get it transferred to like a civil judgment, and that's going to take lawyers, and then they actually have to have money, if they're not working or they don't have the money. There's no like debtor's prison, so there could be very little that can be done. But while they're on parole or probation is a good time, because then they're going to make sure that even if it's a small percentage, that some percentage is coming out and you're getting a little something. But yeah, we're trying to think of what could be a good fix for that, and it's very challenging, because if the person doesn't have any money, yeah, that's a tough one. Anything else? Okay. Am I allowed to find out where the offender lives when they are released from a state correctional facility? And that's probably an OVA question, and unfortunately, the answer is no. That is not information that we can give out unless the person is on Megan's Law. Then that information would be available through the state police website. You could just type in their name and you could see where they're residing. But other than that, no. Anybody have anything different? Okay.
No, I think that's exactly the answer.
All right, this is a tough one and probably one of the ones that we hear most often. What can I do if the DA promises me the offender will serve 85% of his sentence and later I find the offender is eligible for parole without serving 85% of the sentence? Thoughts?
That's a tough one.
Yeah.
Because there's a minimum and maximum sentence. That's what you always hear, a 5 to 10 year or 2 to 4 or something. But how the law is, an offender is eligible for parole at their minimum sentence. So there is no guarantee, unfortunately, that somebody does serve a percentage. So unfortunately, it's just the more accurate information is just the fact that somebody's eligible to be reviewed for parole earlier at their minimum sentence.
Yeah, I would suggest that if someone's making promises like, oh, this person is for sure going to do this, that you could kind of ask for a little more clarification, like what exactly do they mean by that, and what could the possibilities be so that you're not caught off guard. And we did do a Monday night meetup sometime back on sentencing, and that's on our YouTube channel if you want to kind of hear a little bit more about that. It's very, to me, the sentencing laws are very complicated. So I would just say ask a lot of questions and be leery of anyone who's giving you a guarantee of what something. That's a great
answer. The calculations are complicated and you have to be extremely knowledgeable on sentencing to be able to give an accurate answer. So I think if anyone gives you an answer that's 100, like I 100% am guaranteeing you, that right there is a red flag because it is a complex calculation to make. And it's also depending on like what phase in the criminal justice process was the victim told that. Versus when was the defendant actually sentenced.
Yeah.
So there's so many variables there. And I agree that you would need to ask a lot of questions and make sure you're speaking to someone who's very knowledgeable about the guidelines.
Yeah, but and just understanding, like even with all the rights that we've spoken about, that's not something that you would be able to come back as a victim and say, they promised me this, I want to make sure this happens. There's nothing in the statute that allows for that. Looks like we've got one more question. Someone says, my client was asking about reimbursement for a medical expense for her son's hospital bed. Her son was a victim of gun violence. Does this sound like an eligible expense? It sounds like victims' compensation.
Yeah, so what I would suggest, if you have not filed for victims' compensation or reached out to inquire, to please do so. We can, I'm going to put the phone number of our compensation program in the chat so you can call us and we can talk through the eligible expenses, and if you haven't applied, what you can apply for.
Okay, that sounds great. Well, I want to thank you both for joining us tonight. And there are so many people across the Commonwealth that are just providing exceptional services to crime victims. So we want to do everything we can to get the word out so that people can know. We understand that it's trying to walk through something at a time where you are kind of experiencing the most trauma, and which makes it the most difficult to have to walk through. So please know that there are people who want to be there to support, and there are supports in place, and any way that we can help to connect you with those supports, please feel free to reach out to the Office of Victim Advocate, and we can make sure that that happens. We're going to end the show tonight with showing another video from the Pennsylvania Coalition on Crime and Delinquency, and it's about the role of law enforcement officers in providing information to crime survivors about your rights as survivors. So, and then also we're going to be dropping in the chat next month. We're going to be talking to the Pennsylvania Parole Board about victims making comments in that process. So please plan to join us next month and then take a look at this video.
Well, first of all, I have to say thank you for the work that you do, because it is really important work and we really value it. You have almost always the first interaction with the crime victim, and you set the tone. If you develop trust with them, it makes a huge difference in the outcome of the case as well. They're going to be much more willing to participate in the case. And if they trust us, no matter how the case turns out, they're going to have a much better view of the system.
Kenyon was a vibrant 18-year-old boy. He loved basketball. He was a kid who wasn't without troubles, but he was just a good kid. Everybody loved Kenyon. I was at my aunt's house, and somebody called my cell phone, and they said that Kenyon had been stabbed. And I'm thinking the shoulder, the leg. I never thought it was that bad.
So we're responding on scene onto a call where any trauma event, a domestic, a rape, a homicide, all the victims are distraught. The last thing that they want to do is be with the police. They want to go be with their family, be with whoever.
I felt like the officers made the first big impact on what I was about to go through. And that made me feel good, because they could have been, they thought about my feelings. I think they really thought about how I felt as a mom, hearing that your son is stabbed and knowing how bad it was. You would never have been able to tell how bad it was talking to them.
Without empathy, you're not going to be able to talk to a victim, especially while something's going on. Empathy makes our job easier.
As law enforcement professionals and first responders, we play a critical role in providing crime victims with timely information on their rights and the services available to them. This is not only our role as police officers, it is our legal responsibility. We're required to provide the connection between the justice system and victim support services, making sure victims know about all the rights, services, and resources available to them.
We don't have all the resources to meet with the needs of our victim. With the victim's rights resources, they'll be able to be in contact with them after the incident.
We're a team, and they're the first in. And they provide the information about our services, so they can then move on to do their jobs, which is investigating the crime. But never losing sight of the fact that there's a victim in the middle of all this, whatever the offense is.
So the detective came to my house. He just went over the services that was available to us, how they would help us. If we needed anything, he left us some pamphlets, so that we seen everything that they had to offer us. They was always reassuring to us that our child's life mattered.
Victim advocates walk through the system with victims. It's the best way to put it. We're there to give them accurate information, to give them support, advocacy, to let them know what their crime victim rights are, and to make sure their rights are upheld throughout the system. We want to make sure that no one is alone when they're going through this. When victim advocates come into a situation, people's lives have kind of been turned upside down by the crime, and so they need to feel safe and secure We provide, hopefully, that sense of security. That's probably, I think, the number one rule for us. And to make sure then that we explain what's going to happen, how it's going to happen, who's going to be with them, how it works. So we'll connect them with local services, explain how the criminal justice system works or the juvenile justice system, because most people have no idea until this happens to them. And then they need someone to walk with them through this. And that's what we do.
If you didn't have an advocate, you would really be kind of left in the dark about a lot of things. And so having someone who understands the whole process, it made us feel good, and it made us feel like we had somebody that really cared. They made us feel comfortable in the process because it was a hard time for us. So having an advocate was a blessing.
First, we offer the critical things, which is, again, the crime victims' compensation. If there are funeral or medical expenses, or if they're going to be out of work for a while, we want to make sure that they get that information before the bills start piling up, because that's the last thing you need when you're going through a crisis already.
They helped pay for some of his funeral expenses, which if we wouldn't have received those funds, it would have been a lot harder for us to come up with $10,000. Deanna is like my angel. I love Deanna. You know, we talk. She'll call me every now and then. I hear from her during the trial. She was with us. She made sure we understood everything from the beginning to the end, even when it was rough. And you know, you needed somebody. She was definitely that person.
In the end, you know, we'll tell people we can't change what happened to you, obviously. But we can make your way through the system better, and hopefully we can help you incorporate what has happened into your life story so that it's not your whole life, which is what it is at the beginning. So that to me is how I see our role and our goal. And if we accomplish that, then I think we're doing our job.
Hey everybody, my name is Michael Muldrow. I proudly stand before you today as the Commissioner of the York City Police Department, and it's my absolute privilege to be speaking with you right now. Which brings me to this. This information was created by PCCD's Office of Victim Services to make one of our most important responsibilities as easy as possible. Providing crime victims with appropriate notice of the basic rights, services, and compensation available to them as required by the PA Crime Victims Act. Know that the information you will provide will help a domestic violence victim obtain a PFA, help a sexual assault victim receive support to cope with trauma, assist a shooting victim with their medical expenses, aid an elderly victim whose retirement check was stolen get their money back to pay their bills, help the family of an abused child pay for counseling services. The PCCD Victims Compensation Assistance Program can help with medical expenses, lost earnings, crime scene cleanup, childcare, transportation, even money to relocate, up to $35,000 maximum awards. The best news is it's easy to share and there's not a lot to do. This information piece is localized. It provides organization names and contact information for all the resources available in your county. You can share it with a victim by email, via text, or the old-fashioned way, by printing some out and taking them with you. But remember, you must be able to prove you provided the information. You must indicate on the police report that the required information was provided to the direct victim, or if appropriate, a member of the direct victim's family. One last thought. You signed up for this because you wanted to be someone's hero. Well, here's your chance to go out there and be one. Be that person who provides victims with the information they need when they need it most. So if you have any questions, please contact PCCD.
Well, thanks for joining us, and we'll see you all next month, and we'll be talking about victim comment before the Pennsylvania Parole Board. Have a good evening.